So, dear participants, dear friends, it's a pleasure, it's an honor to be with all of you for this second year of Global Digital Encounters. We completed in May a cycle of a bit more than 12 months of encounters, and we decided for the new cycle that is starting now to dedicate it to reimagining intellectual property in a new world, in a post-crisis world, so reimagining intellectual property. A publication has been made and is available on our website that reports on the activities that we have performed during the past year. For the coming year, we are starting with a topic which is really in our heart, and which is intangible cultural heritage and intellectual property. So, while talking of intellectual property in its most classical forms or in its non-classical forms, we are much interested in reimagining how IP can be useful for society. And this is why for us, it's very important that its roles, the role of intellectual property, continues to further enhance the support, safeguard, protection, and promotion of intangible cultural heritage. How intellectual property can play this role, this is what we shall study today. I would wish to warmly thank our supporting entities, our support group, which is composed of young academics who also prepared and supported in the organization of the event. And on behalf of the Transatlantic Intellectual Property Academy and of Fide, we are really grateful to all our fantastic speakers from all over the world who are here today, based on their worldwide authority to advise, discuss, interact, confront themselves even on how intellectual property may be a tool to support intangible cultural heritage, protection, safeguarding, promotion, and at the end, shine. So I would leave the floor right away to the coordinator of the activity, Professor Javier Fernandez-Neschetti, who also wants to make an introduction and welcome you again and again to our family. We are happy to see that there are people connected from all over the world, and we are very, very proud of your trust for our activity led by the Fide Foundation and TIPSA. Thank you.
Thank you, Laurent, and thank you to you all for coming here in this 13th edition of our Digital Encounters. Thank you to the speakers and the moderator. And thank you to Manuel de Santos that has joined us just right now. Okay, so here we are, all the family. Today we will talk about something that, from my point of view, is very, very interesting and that comes to our roots, because do not forget that before we created all that IP system some 1,000 years ago, human beings were painters in caves. And remember that the culture and some elements of the culture were founded on artistic creation. And also the inventions were there in order to treat the illness of the people, etc. So many years before of our system, the cultural heritage was here with us. So I think it's part of our duties as members of the IP community to find out ways in which we can treat respectfully and try to find a balance between the rights of the IP owners and the rights of those peoples that created this ancient culture and would like to keep it as it is. And that's why I think the topic, today's topic is so important. I'm very excited to be here and very grateful to the speakers and the moderator that has accepted this to talk about this topic. And as usual, remember that you belong to a community, you're part of it, so you can participate by sending papers, by raising questions, etc., and keep tuned because we will have more encounters in the following months. Thank you very much. And Benedetta, I think the floor is yours.
Thank you very much. The 2003 Convention for the Safeguarding of Intangible Cultural Heritage seeks to avoid engaging with intellectual property, as Article 3b states that nothing in this convention may be interpreted as affecting the rights and obligations of states parties deriving from any international instrument relating to IP rights. However, the operational directives for the convention do address IP rights. Paragraph 104 states that states parties shall endeavor to ensure, in particular through the application of IP rights, that the rights of the communities, groups, and individuals that create, bear, and transmit their intangible cultural heritage are duly protected when raising awareness about their heritage or engaging in commercial activities. Additionally, in practice, many communities have adopted IP rights, and in the nomination files which are submitted for ICH to be inscribed in the UNESCO lists, states mention IP rights as safeguarding measures. Due to this practice, when the operational directives were amended to include a new chapter addressing sustainable development, paragraph 173 was included. This paragraph states that states parties shall endeavor to recognize, promote, and enhance the importance of ICH as a strategic resource to enable sustainable development. To that end, state parties are encouraged to adopt appropriate legal, technical, administrative, and financial measures, in particular through the application of IP rights. Furthermore, since 2018, the structure of periodic reporting for the 2003 Convention has been aligned to overall results framework. The overall results framework is composed of 26 core indicators. Indicator 14 addresses the extent to which policies, legal and administrative measures respect customary rights, practices, and expressions. Assessment factor 14.1, which provides a framework for assessing this indicator, establishes the criterion that forms of legal protection, such as intellectual property rights, should be provided to ICH practitioners, bearers, and their communities when their ICH is exploited by others for commercial or other purposes. Finally, a recent book of the World Bank and UNESCO states that appropriate commercialization combined with the protection of IP rights held by the producing community can help safeguard ICH and as such achieve sustainable development. So IP rights are not contrary to the spirit of the 2003 UNESCO Convention. As paragraph 173 of the operational directives indicates, IP rights can support the safeguarding of ICH, namely helping communities achieving sustainable development, not only of an economic, but also of an environmental and of a social nature. However, IP for ICH, if not carefully adopted, presents challenges. IP rights can create proprietary rights that benefit few community members, typically the most powerful ones, and therefore causing frictions inside communities and undermining the vitality of ICH. Additionally, during the inscription of certain ICH elements to the UNESCO lists, tension arose as nomination files placed too much emphasis on proprietary rights and commercialization in a way that is not compatible with the concept of ICH. So are IP rights good safeguarding measures for ICH? In that context, I would like to address the first question to the first panelist and to the panelists themselves. How have bearer communities been able to benefit from understanding and using different kinds of IP rights protection, including sui generis rights, in safeguarding their intangible cultural heritage? Alexander, would you mind starting?
Thank you, Benedetta. Thank you for the invitation to this important event. First of all, to understand the benefit of this intellectual property right to protect, for example, in the case for the program that I have leading from Colombia through the intellectual property applied to handicraft. This is the case that I can talk. That's my experience. We have been leading, working on that, and managed bring to the artisan closer to this kind of tools, these legal tools, as all the frame that you share, understand, and give us is working. We have been trying it and this on all this subject and achieved the effective of use these distinctive signs, using them first of all because there was all the time they don't use that, and we accompanied this in the process, and more than the 2,600 individual commercial brands, for example, trademarks, 60 collected trademarks, and also 12 PDOs of artisan in Colombia. We have been in the South America and Latin America, the country with the highest number of this kind of legal process. Through this our program, we have not only helped to register all the use of the intellectual property and trademarks, PDOs, industrial designs. Also, we help them in copyright tools too. In Colombia, for example, it is free for everybody to register. And we give them to copyright users and accompany them in a registration process of their original craft, in applied craft that we call in our country. In this way, we seek the complementary support that they need. Also, in Colombia, we don't have sui generis laws, especially laws to protect their traditional knowledge. We have been working with the Ministry of Culture in the safeguarding of craft, while maintaining their intelligence, looking for to protect the indigenous cultural heritage. That was one of the most important example, the most complete example is about what one of the PDO called Pasto Burnish Mopa Mopa. That's the name. I have some here to show you. This one of the objects of the handicrafts, very known, and it was registered as a PDO 10 years ago. And last year it was inscribed on the UNESCO list of Intangible Cultural Heritage in a need of urgent safeguarding as a traditional knowledge and techniques associated with the PDO, Pasto Burnish Mopa Mopa, from Putumayo and Nariño. That's the geographical area here in Colombia. And as the government, as we have been working at this way that we are working, they need an urgent government help because at this moment they are only 10 harvesters in all the chain value, that the map of stakeholders that we know, that we understand, 9 wood master and only 36 varnishes master, handicraft who work on that. This practice is threatened at this moment, including some factors like, for example, more powerful and this globalization process for youngest people. They don't understand, they don't care about it, and sometimes the scarcity of the raw material, the mopa mopa, and the woods due to deforestation and the climate change. Also, every time it's very difficult to go inside of the forest to look for the raw material. So from Colombia, we have been helping these artisan communities acquiring knowledge about intellectual property, these tools applying in the craft. This is the potential way that they can use. Not only use the legal use in trade of the importance of combating the misappropriation of traditional cultural knowledge has been taken into account in some commercial intermediaries, why they don't respect their knowledge, the traditional knowledge, the iconography, copy them as a new products, copying, doing, making small changes, some small changes, or not giving the correct information about the origin of the craft. That's why we continue working on that. That's what the artisan community don't benefit of this kind of business. That's why we're trying all the time, understanding, and finally, these Colombian artisan communities understand and use different kind of intellectual property rights, and this kind of protection sometimes is not enough to protect them in a market. To absorption, or they believe that if they have a mark or a PDO, this kind of protection, anyone can copy them and make a similar handicraft, or that's why we are still looking, and it's very important that wide group of genetic resource, traditional knowledge, and traditional cultural expression must be continue working on having an agreement that can help us in all around the world.
Thank you very much, Alexander. This was very, very interesting. Please, for participants, if you have questions, put them in a chat. It was very interesting the way you explained us about misappropriations occurring, and also, the way in which you explained that the scarcity of resources for climate changes and deforestation made it even more necessary to create a PDO to better safeguard the heritage that is even inscribed in the UNESCO list, on the list of urgent safeguarding elements. So thank you very much, Alexander. Harriet or Thomas, would you like to add something to that topic?
Well, maybe I'll go first just to add to what Alexander was saying. I think for me, and based on the work that I've been doing in India with Benedetta and a couple of other people, with 3 different communities in India, one of the things that we noticed was how important it was for bearer communities to understand what their rights are. Because, for example, in one case where a young Cho dancer, traditional dancer in India called Mashumi Chaudhry, had a dance troupe that was featured in a movie about their lives, and they weren't actually credited in the movie. So for her, understanding that being attributed in the movie and having her name in the movie was a right, was very important now in moving forward and negotiating with other companies and other people who are using her work in audiovisual material. So that, and I think this helps safeguarding because it helps her then to be better known if she's attributed in audiovisual material, and it encourages young practitioners to enter the field. They can see there's there's awareness about their art form in the wider public, and it also helps them to earn a living. I'll leave it there and hand over to Thomas.
Thank you, Harriet. And thank you, Benedetta, for having me and for taking this important topic on the agenda of the Global Digital Encounters. I'm delighted to be here. What Alexander and Harriet said, I raised 2 points that it's exactly one of the important notions, I think, among indigenous people around the world has been the realization that, first of all, cultural heritage, it is an intangible asset as well. It has political, religious, spiritual, social values. It has also economic value, and that is kind of like conceptually to understand that it is something that should be protected and also can be protected. And the second thing is that the realization that that there is some kind of remedies already existing, namely IP laws that can be used, that maybe the historical assumption might have been some decades ago that there is no rights, you cannot protect, anybody can come and take and do what they want, and slowly to realize that actually it is not so bleak, the situation, even now, even if it's not optimal. So there are some remedies, but of course, if we think like the difficulty and complexity of the legal issues of IP laws, if you go to ask anybody, layman you meet on the street, but what is the trademark or copyright, they are not simple things. Not to mention that when we go to indigenous communities, it's just as complex for them to understand what is a trademark and what is a patent. So it's very understandable that it takes time to build capacities and empower people. I just make two quick examples of my own. My own work has mostly concerned IP rights in the Sami, in the context of Sami people in the Nordic countries. For those who are not maybe acquainted, Sami people are the only indigenous people in European Union. Their homeland called Sapmi covers parts of Northern Europe, and there are about 80,000 Sami individuals living there. And how the communities have been able to benefit from the current IP remedies. There are two existing trademarks, certification marks, that are being used by the Sami people. I took a print since I don't have presentation, but the Sami Duoji mark. It's a certification mark used already since 80s to indicate the authentic Sami handicraft products, so that the goods are being produced by following traditional methods. There is a new mark, Sami made mark, which is being established currently, and the aim of the mark is to message to the public that the goods or services are produced by Sami person. And so these certification marks, we know that there are globally many examples, and I think they are being received quite well by many indigenous communities and used. And this is an example of, let's say, positive or active protection, that the indigenous community goes actively to seek for protection. There's another example quickly I make about, let's say, defensive protection. A couple of years ago, in Norway, Norwegian jewelry company registered as a trademark, a figurative mark, which represented Sami. Well, it was highly similar or same. Here is the registration, and here is the traditional Sami symbol. So it is almost identical. And they registered the mark, and they intended, in the end, to prevent Sami artisans of using this traditional symbol and claim their proprietary right to that. There was a public outcry among the Sami artisans and community. Eventually, the registration was invalidated, since it was deemed to be contrary to the public morality and would have prevented the Sami artisans of their access to their traditional symbols. And if I may advertise, Harriet has written an excellent article on this, ethics, intellectual property, and commercialization of cultural heritage. I strongly recommend to read that. But this latter case is just an example of defensive protection. And the question was how the communities have benefited from understanding IP rights. I think this resonates here, that also the Sami people, artisans, understand, hey, wait a minute, this is intangible asset, this belongs to us, there must be some remedies, there is active participation, communications to the authorities, and the process starts then to prevent this kind of like appropriating registrations. Well, I leave it here. Thank you very much.
Thank you very much, Tuomas. Actually, what you are saying leads us immediately to question number 2 that I would address directly to you, Tuomas, as a start. So the question is, what have been the challenges faced in doing so? So namely in adopting those trademarks that you showed us, both in a positive or in a defensive protective way, and how have these challenges been addressed, for example, by using also alternative or complementary strategies such as ethical codes or consumer boycotts?
Thank you, Benedetta. I'm happy to continue. I try to be a bit more brief, but yes, as already raised earlier, first important step has been to raise the general awareness of the fact that ICH, TKTCs are intangible assets that should be protected. And I think the idea of this protection is very justified also from the point of view, from the logic of IP law, since if we look carefully, we see that these expressions, traditional expressions, they are products of human intellect produced in over-generational processes. Designs and symbols used by indigenous communities, they are also used in distinguishing purposes to communicate and indicate certain groups. So there are a lot of similarities in between TCEs and IP objects as such. One challenge in using IP to protect TCEs is the fact that if some TCE would be protected by, for example, a trademark or a copyright, it must be perceived as intellectual property object. And this requires legal definitions, which might be difficult to make within traditional context. For example, TCEs, these expressions, they might have various forms. They evolve. They are not like a static, but there's also always like a cultural development, even gradual and slow, but development. So if protection is being applied, its substance must be defined, and there is a risk, of course, like a difficulty to define it, and of course the definition itself might pose some risks for its evolution. It must be also, of course, legally speaking, decided that who is the owner of the trademark or who is the owner of the copyright. And if we look at the indigenous communities, the ownership structures might be quite different than the concepts of ownership that we can legally think. And also the definition of what does it mean to own something, that who can license the use, how can it be used within individuals and the communities. So conceptually there might be differences, and this combining them is not definitely impossible, but it of course requires capacity building and time dialogue between the IP experts and indigenous communities. Most importantly, I think what IP experts, authorities can do, I think, is to listen, to try to understand and what is the, let's say, desired state of things from the point of view of indigenous communities, because then it can be matched in a way with those remedies that there are, and see if it doesn't work. And yeah, well, thank you.
Thank you very much, Thomas. Thank you so much. So maybe Alexander, could you jump in and tell us something about other possible cumulative or alternative remedies like code of ethics or boycotting strategies that communities may adopt, and also governance bodies for PDOs or collective IP rights associated to the heritage in Colombia? Thank you.
Okay, Benedetta, I continue with my examples. Okay, not only in this case, the boycott was by the consumers, was the producer, the artisans. It happened 8 years ago. One of the most important challenge at this moment was that we can show that the artisan that this kind of IP legal tools works. It's because sometimes we help them to make all the process, the legal process, but when they don't know how to use, it's very difficult. This case happened with these special artisans from the Senu indigenous community from the north side of Colombia that produce our volteado hat. That's our volteado hat. This is a Colombian cultural symbol. Yeah. We use it all the time and very known around the world. Our sports singers are very known and they use it a lot. It happened 8 years ago that it was illegal hard copies in Colombian market, in tourist markets, and reported about the usurpation and that the situation, the Masuri areas were affected with this counterfeit craft. Make it in paper or plastic. It's unauthorized copy, apparently made on China. Apparently, we don't know, but it happened that way. We begin to work from our program, from the train industry and tourism ministry, and with the Colombian Intellectual Properties Office and all the and others working on a meeting, taking advantage that we had IP legal protection of this product. We have PDO and we have at the same time a collective trademark called in Spanish sombrero vuelteado. That's the name in Spanish. Our Colombian office order at that moment preventively enacted the suspension of production, marketing, sale, or all hat that imitate or seems to be or represents or resembles or evoke that kind, that hat, our hat that identifies this video, the calls in Spanish, that's a new weaving. And it's also not only in this kind of protection, based also in consumer laws. Yeah. And this why how the Colombian government took border measures and containers arriving from China that it's similar and that unauthorized copy can come from Colombia. And at that time, 70,000 unauthorized copies were destroyed. The indigenous reservation called San Andrés de Sotavento in Spanish, in Colombia, Caribbean, is made about 10,000 indigenous, most of them dedicated to handicraft, working on that. The authority declared it and proceeded to raise and seizure the raw material, and they say Chinese hats, and they destroyed it too. Some measures that we took at that time too is used to our Colombian video seal, similar as you know, as you have in Europe Union. See here in South America, we have in Chile, in Ecuador, and here in Colombia. That's measured to identify videos products in markets and facilitate the market surveillance that fights against counterfeits. All the situation. We help them with new advertising, explaining how to identify that original hat that now the consumers make a boycott, ask all the time to the handicraft, show me that's why this is original, why? Tell me why. And we give them many advertising about it. We work them too in a tourist and artisan route to help them, and an artisan and cultural fairs and folklorical parties that helping them in all subjects about heritage. We must continue in this control on these unauthorized copies with plastic and volteado hats and support, but all our Colombian authorities.
Thank you very much, Alexander. So this was very interesting to say. What you said actually is completely linked to what Harriet said before, and Thomas, of course. But when Harriet said it's very important that communities understand that they have rights, and then it's also very important, as Thomas said, this is not easy to explain them which rights they have, but then it's also very important to see that those rights can lead actually to positive results. So this is very, very important, and thank you for the examples that you provided us with. So this leads me to the third question, and I would like Harriet to please start replying to that. So how can intellectual property rights strategies be better integrated into heritage safeguarding and awareness raising or promotional strategies, especially where bearer communities aim to use their ICH for sustainable economic development, for example, through tourism or product sales?
Thanks very much, Benedetta. I put a link in the chat in case anyone's interested of a project that we've been doing in India called HIPAMS, Heritage Sensitive Intellectual Property and Marketing Strategies. And the reason we put this project together was that we noticed it was actually difficult to integrate considerations around intangible heritage safeguarding on the one hand with considerations around IP protection or promotion and marketing of cultural products. And a lot of the resources that existed for communities were either on ICH safeguarding or on IP protection or on marketing cultural products, and not really how to think about all of those things together. And so, as I said before, we worked with 3 communities in India to try and develop some strategies for their own products that they were wanting to place on the market, and thereby also think about this bigger question: is what does it look like when you think about heritage and IP and marketing all together? And this is particularly important because of the issues that Alexander and Thomas have been raising, that actually there are risks to putting one's cultural heritage products on the market, or experiencing misappropriation in a market context. And it's actually quite hard for communities always to act and to take a problem to court, because it costs money to get good advice. You don't always know what your rights are in these situations. And so in the HiPAMS project, we tried to look with communities at what the problems they were facing in the market environment, and then to develop some strategies. And one of the issues, one of the strategies we looked at was the development of ethical codes. And that actually helped not just to educate artists, but where artists had, were in not such a powerful position in regard to their consumers, artists really were grateful at having a printed art code that they could show to a customer and say, look, actually, these are my rights. If you want to use my design commercially, then you need to ask my permission. You can't just take my design and then put it on a candlestick and start selling it. So the art codes were useful in the negotiation between artists and consumers, and they also helped to raise the status of artists. We used the Intangible Heritage Convention's ethical principles as the basis for the art code, but then we tailored it to the actual needs of the community members. And I think the other useful thing that came out of the strategic discussion was that we based the work on what artists identified as the heritage they wanted to protect. And then we talked with them about what is the relationship between what they wanted to protect against what the products were in the market, and made sure that their heritage skills repertoire was then maintained through their engagement with the market. So just to finish then, the 4 key issues that came out of our HiPAMS work was to look for problems and solutions across 4 dimensions: community governance and empowerment. What is the way in which communities want to manage their engagement with the market? What is the knowledge about IP rights or marketing? And then what are the skills they want to protect, the heritage skills repertoire? And then finally, looking at reputation, not just in the market, but in the community itself. How is the heritage valued? And finally, to look at heritage sensitive innovation, because a lot of traditional artists feel a bit trapped in the tradition. They feel that when they start changing things, that they get on shifting ground. And so open up some of those conversations around innovation in the market, but keeping it heritage sensitive. So I'll end there with that strategy.
Thank you very much, Harriet. This was very important to focus at. And I would like to ask Thomas if you experienced similar situations with the Sami. So are they benefiting from codes of ethics or boycotting strategies or similar sort of strategies in addition to intellectual property rights?
I just add what Harriet said, and also Alexandra, that it is exactly like key notion to understand that if we think that there is law protecting something, that law protects trademarks, so law doesn't do anything, but you have to go actively. Even if you have a trademark, you have to be active, since it's a private law mechanisms that we are talking. So there is no authority that would come to deliver you protection as far as we talk about IP rights. And I think this is exactly what we are hearing about in Harriet's and Alexandra's speeches and it's very positive. I have example I mentioned also which illustrates this in a way empowered attitude to some extent. For example, in the Sami community are now currently made in cooperation with Disney company, which probably everybody has heard about, but the Frozen 2 movie was filmed and released, I think, this year, and I was not engaged personally to these negotiations, but I know something about it, and I think the story was that Disney approached to produce Frozen 2 movie Sami communities and originally, and they were interested about the narratives and stories and like folk tales within Sami communities, and Sami shared these stories and told, and Disney gathered and collected many things, but it was left a bit like unclear that how this material is going to be used and what are they going to do about it, since then the artistic representatives left. And afterwards, then Sami parliaments and Sami communities actively contacted Disney and addressed the issue that in constructive manner, that look, that if you are going to use our culture and express our culture, we should be involved, and the consent of Sami people should be involved there. And fortunately, it produced in fruitful cooperation between Disney and the Sami communities, that Disney they recruited and Sami representative to the production team, and they saw that how the Sami culture is being illustrated in the movie. Movie was dubbed also to one of the Sami languages, and there was like a good cooperation between them. And this well, to the question, might illustrate this like kind of like active stand on the side of indigenous communities, even if there is not exactly like a IP right at hand, but to, in a way, to go forth and say that, look, this belongs to us, this culture, these expressions are from here, and they should be respected if they are decided to use for external economic benefit or such. And this leads to my final point of this speech, that ethical guidelines, for example, Sami people have, Sami parliaments have issued several ethical guidelines. There are guidelines on photographing Sami outfits and culture, use of Sami dress, filmmaking, if you use Sami culture in filmmaking, travel and tourism services. So this is a good point, that there are many third parties who have a desire, who want to respect, who want to approach and use traditional cultural expressions in a respective manner. So the ethical guidelines can serve that purpose very well, that you can articulate well that how can you in a way behave well, how can you respect, what to take into account, and it's like a written material which is very, very useful in this sense, since we know that many companies, many individual consumers want to be ethically also sustainable. However, also the Sami representatives have pointed out that the ethical guidelines as such are not sufficient alone, since it only like works if there is also willingness to be sensitive on the side of third party. But yes, that's one element in the whole picture, right?
Thank you very much, Thomas. With regard to ethical guidelines, I may just add to what Harriet said, that for one of the free communities that we worked at in India, the ethical guidelines were directed mainly to researchers. So it's very interesting to see that it's not only for consumers or third parties, meaning commercializing third parties, but also researchers and universities. And in particular, it was the bowl community that were approached sometimes in a wrong way by researchers without the due respect. And also, I wanted to clarify that in the codes of ethics for India, intellectual property rights were mentioned. So when included in the codes of ethics, saying we know that we have certain rights, in particular IP rights as well. And so this helped communities achieving better treatment. So, Alexander, do you have cases with ethical guidelines in Colombia or codes of ethics or similar approaches to tell us about? Thank you.
Of course, Benedetta. All our 12 PDOs, artisan PDOs, includes code of practice. We have been working, and in the legal process, we have to declare it, and at the same time, we need that they need to authorize to use the seal, the Colombian PDO seal, applying the code of practice. Yeah, all the situation that the standard situation that that give all the GI area, well, all the points that one code of practice includes, and this I want example two that we are working in thing from Artesanía de Colombia that I belong is a jewelry fashion program to avoid usurpation. We have been creating this human and commercial relationship between artisan and jewelry fashion industries. We are looking and adding new handicraft products we're working to include news and some examples, all benefits agreement and successful agreement where we help them to develop in-house collaboration, made in collaboration with artisans, and we invite the independent fashion designers to include the artisan techniques on their collection, all the time asking to them to negotiate and respect their traditional knowledge. We, as a government, we help them and we support them, but this is a private negotiation, yeah? But one way, when they asking us what to do, we call us and ask through this kind of programs to help them that they don't give all the information to all people. And also, as Thomas example gives about Disney, we are at this moment working in a movie called Enchant. It's from Colombia. It's very known about our country, and we are working, explaining, negotiating, and respecting artisan, Colombian artisan traditional knowledge. It is on movies, on theater, maybe in next November of this year, and we are looking for the authorization to use some of our handicraft, our very known handicraft from Colombia.
Thank you very much, Alexander. So, and thank you, Thomas, and thank you, Harriet, and thank you to the Digital Encounter for this wonderful opportunity. So, just to take some conclusion, I think that this Digital Encounter has aimed to contribute to the ongoing debate surrounding the relationships between intellectual property rights and intangible cultural heritage, and to engage with the positive effects and potential pitfalls of adopting intellectual property rights in the context of ICH. There are cases where adopting and enforcing IP rights poses challenges and impedes the attainment of effective sustainable development. Like any protective legal mechanism, when IP rights are not carefully adopted and are not applied in a manner consistent with UNESCO's ethical principles for safeguarding ICH, they are not beneficial and can be actively damaging to ICH. Such cases demonstrate that the adoption of IP rights on ICH is not an easy task, and that strategies to effectively safeguard ICH in a sustainable manner must be devised carefully. However, as ICH safeguarding measures, IP rights may support the sustainable development of the living heritage to which they are associated. IP rights can provide both positive and defensive protection for ICH. Positive protection involves communities registering IP rights on their own ICH to achieve the desired protection. To achieve positive protection of ICH through IP rights, the correct IP rights must be selected to provide the type of protection the ICH practicing community desires. Additionally, IP rights must be drafted with full community participation, as well as exceptional care and accuracy if they are to provide protection against misappropriations. Defensive protection entails communities defending their ICH through IP rights that infringe their ICH. Other legal rights complementary to IP rights, such as access and benefit sharing agreements, codes of ethics, cease and desist letters, image personality rights, and boycotting strategies can also be implemented to provide defensive protection for ICH practicing communities. Ultimately, IP rights are regimes of governance that need to be carefully designed in order to fulfill an optimal range of social, environmental, and economic sustainable development objectives. Thank you. I will hand over to Manuel now, unless there are questions. No. Okay, Manuel.
Hi, Benedetta. How are you? Thank you very much. I think we still have time to open possible questions. For the first time, we have developed, or the infrastructure of the device have developed the possibility of asking the questions directly. Until now, questions had to be written down, but now we can get the questions directly. So I think we could have around 20 minutes to have questions. The case being, so any of you who are attending and you would like to ask a question, you're very welcome. And so just raise your hand. Yes. There's a question for Alexander. If I may ask
no, that's a question, but maybe it's a conclusion, or if we were almost finish our time, because our as a lawyer, as my point of view, the IP tools are well adopted for preservation, promotion to traditional knowledge and associated to biodiversity of indigenous people and local communities. In the case of GIs, we open to local producer at the meeting of GI specification, code of practice, all that they said, based permanently linked with the qualities product on a specific territory area, collective traditions, while allowing products to a specific environment, protected all around the periods, a collective tradition is made, and as holistic nature, involve nature, climate, law, culture, people, society. But that's where we have a problem here to finish. IP tools protect only names, only the names, the sign, yeah? The name of the community, the name of the product, but no method of production, no knowledge, no designs, no tradition, no biodiversity. That's why we have to continue working, that this is important to know that IP tools works, but not enough. There's not enough to preserve and to protect and have all the work that it's very important in the intangible cultural heritage.
Thank you, Alexander. I believe there are two questions. One is a written one. The other one was proposed time ago by Joanne Orr, who wanted to take the floor. Could you like, Joanne, to be the first one taking the floor apart from the speakers and the organizers in the history of the encounters? You're very welcome. Let's see whether the system works. We are testing. Joanne, are you there?
I'm unmuting. Hello?
Yes, how are you?
I'm good.
Welcome. That's great. Yeah.
Turn on my camera.
Thank you. Let's do it, please.
Hello. It's good morning, everybody from Canada.
Thank you very much for joining us.
Just a question around this community participation, and as you've got the state, the legal frameworks, and we are producing the codes of ethic iteratively. So we're building case law, and it's always very different across the world in different systems. We've mentioned around the complexity of different ways of thinking and seeing in indigenous communities, and that tension with that sort of state legal system. So it's very complex. and how in the future do we see the development of the codes of ethics, the guidelines starting to influence the actual legislation frameworks and the way that these are set up, often in a very colonial way. How can we gradually influence I think the Sami one is a great example of something practically happening, but how in the future will that affect case law and make those changes so that ICH is central to actual thinking in legal cases?
Thank you, Joanne. Who takes the floor? You would like to jump? Thomas, you're very welcome.
Thank you, Manuel. I can try partly. I don't know if this is an answer to the question, but yes, I pick up this what Joan said. To begin with, I think, like was addressed in the speeches also, that the needs of the communities and indigenous people should be put first in the whole assessment, to start there. And that is exactly I think the terrain where the let's say conceptual differences should be found. How, for example, what does it mean to own something in traditional sense? Who is the owner? I mean, because, and it's too easy for us maybe to think of in legal terms that, okay, if you are a proprietor, it means something, and we take the substance of this concept from certain legal system, which maybe is not so applicable. And this is very good point. This, let's say, conceptual colonialism might be strong, I don't know, strong wording, but it is true that if we think that we have some core concepts, let's say the owner of a trademark or the author of a copyrighted work, these IP laws, they have very individual background, individualistic thinking background, and for us it's easy to conceptualize that there is something private, and what is not private is in public domain, free for all. But in traditional context, often we see that there is something between there, something what is not private, but it is not either free for all, something communal and collective. And this is something I think, legally speaking, also would be interesting to develop and examine further, that how the levels of ownership in collective terms and communal terms can be transmitted to the IP laws and legal. I hope I answered at least to some part, but thank you for the good question, John.
Thank you.
Harriet, please, if you want to take the floor, Harriet.
Yes, I just wanted to say something very briefly. I think Joanne's asked a very good question. And what really interests me looking at IP law is that there are opportunities and places already within IP law, for example, in the public policy exception that prevents the registration of IP rights contrary to public policy and morality, where we could start sort of reinterpreting what that actually means. Is it moral to register an IP right on some indigenous cultural heritage that's actually, as Thomas said, not appropriate to be shared or used by third parties? And so I think we also need to look at the sort of colonial structures of conventional IP law and see where there's already opportunities there to start rethinking how those get implemented.
Yes, thank you, Harriet. I just wanted to remind that there was a case that went up to the European Court of Justice on Lindt chocolate case, and they used precisely bad faith to avoid the registration of a trademark, a shaped trademark for bunnies, chocolate bunnies, because this was against German traditions of chocolate to be sold in Easter. So they used the IP system to go against this registration. This is a very interesting case, but there are others. And another thing that maybe I will ask Thomas to clarify. In the Sami case, the trademark was, one of the trademark was actually registered by a member of the Sami community, correct? So it was, so to say, a registration contrary to the tradition coming from the same community.
No, as far as I understood, it was the external jewelry maker who was not Sami, part of the Sami communities, but the external operator, having a background in jewelry business long time. But yes.
Okay, good, thank you.
Very good. Benedetta, there was a question from
Flavia
Flavia
Guerrieri. Yeah.
We could ask Flavia to join us or just read the question. It was addressed to Alexander. So Flavia, are you there? You would like to join?
I am. I don't know if you can hear me.
Great, very good, excellent.
Okay.
Yeah.
Okay.
That's great.
Yeah. Actually, good morning, everyone. Actually, my question relates to how conflicts are handled within these communities, and if in cases where the codes of practices are, let's say, in the case of geographical indications, are formulated in a strict way, if there are some stakeholders, some producers that are excluded, how this situation is handled. And I saw that Harriet put a reference on Beetle case, but I was wondering if in the cases that Alexander mentioned, the issues were differently handled compared to what can happen in the handcraft sector or in the agricultural sector.
Okay, Flavia, you says it's very different that we have been working in Latin America with handicrafts, because agriculture sector in industrial and agricultural products that we have here in Latin America, for example, was the most known for our PDOs is Colombian coffee, and it is one of the most known around the world. But it is too different, and it's a different world, I guess. This is small groups, small groups of people in a just specific area specific. They work together during many times, and all the process, not only from the raw material, the transformation is on that place, and must be included in the code of practice. And as you said, it's very different how all the tools the intellectual property works. For example, in Europe, handicraft PDOs still doesn't exist. Yeah, that's why we in our trades, for example, from Colombia to America with European Union, it's not easy that they can understand and all the PDOs that we have. But we're still working, and we're still working during many years, and we hope to continue doing and helping these communities.
Mm-hmm. Thank you, Alexander. Laurent,
Thank you.
You're welcome. No, you have to unmute.
I have a question, and more than a question, I have a comment. Okay, there is a major and leading role from Northern Europe, from Scandinavia, on protecting and defending indigenous people's rights, and also in finding interesting bridges between intellectual property issues and indigenous rights, just as mentioned by Benedetta during her introduction. There is a long tradition in Latin America, and in particular in the countries of the Andean Pact, for such development of tools of protection and interaction between the system, the IP system, and indigenous rights protection. However, I'd be interested in this presentation today that we talk about Africa, and in particular about the tools that are being developed, in particular in the free trade agreements that are offered by the European Union, by the US, by Switzerland, Japan, China, to African countries. What about this? I would be fascinated to understand more what those who are less in the front line are offered and how they can be assisted as well in this respect.
Harriet, yes, do you want to go ahead? Yes.
Yes. Well, I mean, I'm not an expert in all of these issues, but I've done quite a bit of work on the Kenyan legislation on traditional knowledge, which tries to really give actually quite extensive rights to indigenous communities and around cultural heritage resources. And I think that there is an IP chapter in the Continental Free Trade Agreement that mentions traditional knowledge. And that is going to be quite important at a regional level in perhaps harmonizing some of the provisions in African law. But I think the real issue really is whether that will help these countries to deal with misappropriations that happen from companies that are based elsewhere, because of course it only really helps within Africa. And I think that what we're also seeing is that geographical indications are being used more widely in African countries. People face the same problems in a way in India, that you've got this problem of collective organizations not having the resources to do quality control and enforcement of the GIs. So it will be very important to see how governments assist, and that's actually going to be a challenge. But I think the real issue will be to what extent does the Continental Free Trade Agreement replicate some of the Kenyan, Zambian and South African models on TK at the continental level, and then to what extent are they going to be constrained by multilateral trade agreements with other countries, or in fact encouraged by especially the EU agreements to push the GIs, because that is happening as well. So that's all I can say. I mean, others may have more to add.
Yeah, fascinating reply, and this is really where I wanted to bring us to. Thank you so much, Harriet, for this.
I may also say that with regard to ICH elements, the African elements, I mentioned that, for instance, in Botswana, they intensively worked on copyrights for an element that is inscribed in the UNESCO list. In Mauritius, the same, they worked on copyrights. And then Morocco, in particular, adopted GIs for argan oil. And with regard to what Harriet mentioned, they tried to register the GI in the European Union as well, as a third country registration of GI, but this registration was somehow stopped for several years. And then a bilateral agreement, European Union, Morocco, was meant to be concluded for the mutual recognition of GIs, including argan oil GI. But then I lost track of this agreement. So maybe somebody can help me tracking this agreement, because I really want to know if this GI for argan oil is protected in the European Union or not. But actually is what Harriet said. It depends also on European governments to help African countries.
Yeah. Thank you, Benedetta. Thanks very much. I have to confess that I'm obsessed by this topic here. And my obsession started many, many years ago when I had the challenge to visit the Kuna community in the east of Panama with my dear friend Eusebi Nomen. You know, the Kuna community, they are very well known for their wonderful molas. Yeah? And I understood then, while studying what they were doing and the way they were moving on, that intangible cultural heritage, traditional knowledge, trademarks, geographical indications, even patents were at the stake there when approaching the matter. So this is the wonderful complexity. Yeah? But you know, I have also to confess that when I approach both from an academic perspective, but also from a practical perspective, this matter, I always wonder whether we are talking about two complete different things when we refer ICH from the developing countries perspective and from the developed country perspective. For developed countries, intangible cultural heritage is a question of proudness or a question of reputation. But for the communities in developing countries, it is not a question of reputation. It is a question of survival. So I wonder whether you could dig a little bit on this issue. Do you agree with this vision, or I'm completely wrong? And if it is so, what your proposals could be? Are we really referring, in fact, to two complete different things, which we probably should not mix, and we are mixing them? And we from developed countries, we address this matter as if the matter would come at the same way the matter comes from developing countries. I'm quite confused, and I do believe that this question is at the heart of all the discussion of the future 20 years of this matter. That's I just throw the stone to you. Who takes the lead?
Okay, Emmanuel, I would like to know you to share that Colombia also have a Gunadule community indigenous too.
I know.
Okay, that 100 ago we were just one nation. And as a program that I lead, we help them in a collective trademark called Asoy Mola, the association from the production of mola. And I know that's 2 years ago, I guess, a very known case that happened them with very sportive shows, very known, that want to use the mola design in their shows, sportive. It's very known brand around the world, it's Nike. And they begin to fight against them using, and not only from Panama, from Colombia too, and they ask them that don't use without their authorization that kind of that design. Also, we said that the IP tool works not only to use names, but it is very difficult that at the same time we can protect designs or the same mola designs that the sporty shoes, very known, use them without their authorization. They fight against them and they won, and it is one way that they stop that that situation. We have been working, we hope so, with the WIPO help maybe at the future in a binational collective mark will be.
Thank you, Alexander. Benedetta.
Yeah, Manolo. So thank you, Alexander. So to reply to your very difficult question, but here we accept the difficult and easy questions. This was a difficult one. So I work as a legal advisor for the violin craftsmen in Cremona.
Yeah.
And actually they are aiming to have a PDO for non-food products. They are working with the European Union to have this regulation at the end. And here I think it's not a matter of reputation, it's a matter of surviving, okay? Because they are really struggling in Cremona, Manolo, believe me, with the COVID pandemic. This really rendered the situation terrible. There is an article in BBC, and I will send it to you, 160 violin makers, and a lot of them will close now.
Closing the door.
Yeah, and they're really, so I don't really see anymore this huge difference, to be honest.
Yeah. Okay, that's a good answer.
I think it's not only reputation in Europe now.
Good answer. Good. Harriet, do you want to say something very brief, just as a conclusion on this matter? And Thomas, just half a minute each.
Yeah, I'll just briefly say something about this question of this idea of sacred heritage and profane commerce, where this idea that heritage isn't about money. And I think that it's not only about money, but if artists can't live and give a profession to their children, then it doesn't last always very long. And some kinds of heritage practice are never going to be in the market. They're rituals, they're things that are not for commodity, for commercialization, and that exists everywhere. There's some things that go in the market and some things don't. So I do think it's a kind of false dichotomy that it's either meaningful or it's commercializable. I think things can be both. And so this question, I think, is going to dominate the next 20 years, and hopefully we'll have a more complex answer in that period.
Thank you, Harriet. Thomas, your conclusion?
Yes, thank you. Yes, I think we are in this fundamental question, like Harriet raised out, that how does the protection might affect to the thing it is protecting. When we define certain TCE or a custom, we protect it, we defined it, and it's being used maybe out of context due to the fact that it's being protected. So I don't know, there's a high level of sensitivity must be included in this elaboration, and only time will show where things will evolve.
Thanks very much, Thomas. Thank you. The other questions, I've seen questions also from Gabriele, the other questions, but unfortunately, while all these questions will be taken on board, I think we have to close little by little. So let me come to my last words, thanking everybody. First of all, thank you, Benedetta. Thank you. It was a great and I should say a profound discussion. Yeah, it was a discussion full of very valuable reflections. Yeah, the issue is very, very complex. Yeah, very controversial also. Very there to our common future. Very there to all of us. Yeah, and as it happened with all the other encounters, we do have to review again and again now the recording to learn more. Yeah. We have to read the report and we have to reflect on the questions which have been brought, the answers, and the questions which unfortunately we could not take on board for lack of time. Yeah. So thank you to all of you who have asked questions. You know that the questions are not lost. They will be published later on, and this is food for thinking. Yeah. Thank you very much to our speakers. Thanks to Alexander. Thank you to Harriet. And thank you to Thomas. Congratulations to Professor Bertazzi. You have conducted in a magnificent way this encounter. 1 hour, 50 minutes have passed so quick. Yeah, so quick. Yeah. But above all, thank you very much to all of you who have been connected today. As I always say, you are the protagonist of the Encounters community. And as I always said, I would like to highlight also the presence of all our students, yeah, students who come from so many different countries. I would like to thank you, especially all our members of the Encounter support team. This time, the draft report will be written by Eetu Uta, and who's come from Finland, and by Florence Boyd, who comes from France and from the United States. Both are members of the Encounter support group, of course. Yeah. As I always call to your attention, if you are a doctor or a recent doctor and you feel like joining the Encounter support team, please let us know, and we will immediately enter into contact with you. Yeah. So I guess also that you all had the opportunity to have a look to the book who was just published online, and which contains the objectives, the references, the videos, the reports, the questions proposed by the attendants of each one of the 12 first encounters. I have the feeling that the book contains a terrific amount of useful information, and this information covers many, many different aspects of the future of intellectual property from very different angles. I guess when you will read the book and when you will come to the book again and again, you will enjoy them. Each encounter is a world by itself, yeah. But all together, when you keep them all together, this is the 13th, they form a splendid source of knowledge. There are dozens and dozens of interested people who are following the report on the spot, but there are many, many more others who study them later on, who watch the recordings, who read the references, the reports, the questions, and so on and so forth. Yeah, we are very grateful to all of them. We appreciate whatever advice, whatever criticism, or whatever suggestion you can give to us, please. Yeah, we do believe this is a very valuable legacy for the future, but we do believe that this is a common legacy which belongs to all of us, the encounters. Yeah? But this is not the end. Our 14th encounter comes next 15th of July 2021. There will be another topic as complex as relevant, data economy. Yeah. As always, we will enjoy moderators and speakers coming from all over the world. So let me close this encounter by thanking very warmly to all of you, by encourage all of you to read the report, and by encouraging all of you cooperating with the encounters. And as I always say, please take care. Please take care, yeah? And come with us in 1 month. Do count of you for our next encounter, July 15, 2021. Enjoy the day. Bye-bye. Bye-bye. Thank you.
Thank you.